Welcome back. Some new information in the case of an upstate New York man going on trial for the fourth time for murdering his wife. Cal Harris waiving his right to a jury trial, choosing instead to have a judge hear the case. And here's a look back at how all of this has unfolded. In 2001, Michelle Harris files for divorce, but the couple continues living in the same house with their 4 children. Several months later, on the morning of September 12, 2001, Michelle Harris is reported missing by her attorney, who was contacted by one of Michelle's female friends. And then, September 30th, 2005, Calvin Harris is indicted by a grand jury on 1 count of second-degree murder in his wife's disappearance. On June 7th, 2007, Harris is found guilty of second-degree murder, but just after the guilty verdict, a new witness comes forward, claiming that he saw Michelle the morning after she was reported missing, arguing with another man in the Harris driveway. In July of 2009, Cal Harris granted a second trial and is found guilty for the second time, but the verdict is returned on appeal because of 2 procedural errors. And then in May of 2015, Harris's third trial begins, but the jury comes back deadlocked and a mistrial is declared. Harris's 4th trial is set to begin this Thursday. Lise Wheel, she's a Fox News legal analyst. Bob Bianchi is a criminal defense attorney and former head county prosecutor and trial attorney. Wow, this case has been going on and on and on, and he is choosing for it to continue, but this time without a jury trial, just allowing a judge to hear it. Is that a good move? What is his strategy?
Very unusual. As you know, I've been covering it on Wheel of Justice on my podcast for our FoxNewsRadio.com for over a year. Been up there, talked to all these folks, prosecutor, the defense lawyer. Defense lawyer is making a strategic decision here. It's very calculated, maybe wise in my estimation, because he's estimating that the jury is looking at this very emotionally. The last trial was split fairly evenly, deadlocked, as you know. So he's saying here, the judge is going to look at some new evidence he's going to produce, and we'll be looking at this evidence and facts as opposed to the emotion, and may, for this 4th time around, say, we're going to let him go. That's what he's calculating on.
But, Bob, you disagree, right?
Yeah, I think this is a basic 101 criminal trial law. You are now reposing into one person. There's been a lot of media attention. There's a lot of pressure. Remember, these judges are elected. They respond to public opinion, even though they're not supposed to. We all know in this world. Now, instead of getting 12 people to have to find beyond a reasonable doubt that he's guilty, only one singular man is doing that. I've only done this once in my career, and that was after the judge was basically telling the prosecutor he felt the case was not good, and still I struggled with not going before that jury. Just like the last trial he had, a couple of jurors decided he was not guilty, and that caused a hung jury. I think that this is a tragically bad mistake by the defense.
But twice before, even though it was overturned, the jury found him guilty.
Which got reversed. And here's the thing, prosecution's cases never get better with time, right, Lisa?
They don't. On the other hand, if they can show this judge new evidence, there was evidence apparently of in this
fire pit.
Fire pit. And why, you know, these 2 people that one of them now is in prison, why did they leave right after her disappearance? There were things that were brought out after the 2nd and 3rd trial, legal miscommunications or legal due process not found. I mean, there are a lot of things. When I went in to investigate this, I thought Cal Harris absolutely guilty. But the more that I looked at it in this podcast, I mean, it took, you know, months and months, and again, of going up there, looking at the evidence.
Because her body has not been found, no murder weapon has been found, so there's a lack of evidence on both sides.
Exactly. And the prosecution bears the burden, don't forget.
Bears the burden of proof beyond a reasonable doubt to a moral certainty of guilt. Now, let's not forget, it's 5 years after the incident until he even gets charged. That's a major thing the defense is going to bring out. There's newly discovered evidence. I have literally been involved in investigations where there's a divorce happening, and the investigators and detectives automatically by default go, there's the motive, there's the suspect. I actually stopped an arrest of a husband in a particular very brutal homicide in the county that I was running, and ultimately it wasn't the husband, it was somebody else.
Because usually that is.
But do they do that strategically, just in terms of timing of the investigation? Do they look at the husband first to see if there is any family member, if there is evidence to warrant a continued look at that person? And if not, they say no and move on.
But here's the thing that this tells me. If it took them 5 years to make a decision to charge the husband, they were kind of randomly not understanding what was going on here. It doesn't take you 5 years to charge somebody when you believe you have enough evidence.
Yeah.
Well,
That's
but
the
there
first
were
thing.
other things coming in. That, for example, you know, really getting into the weeds here, there was a hairdresser that Michelle spoke to, and then that was hearsay evidence was coming in. So there were a lot of things that they found out down the road.
Right.
But then these two people now in the pit and all of that, that's evidence that's coming in even now. So there were just a lot of things that really took it took some time.
And they found a witness that actually said that he saw her and a younger person having an argument in the driveway.
Right.
This
The
is
day
stuff.
after.
The day
she
after.
reported
This
missing.
is stuff the
Right.
prosecution should know about from the beginning of the case. My experience has been, once an investigative decision has been made, you have to slow those detectives and investigators down because it's the square peg in the round hole theory.
But now this is a different prosecutor as well, so there are a lot of
Now,
things going on in
his
the small
children,
community.
his 4 children,
Right.
say that he is innocent. Will the judge in this format hear from them?
No.
No?
No.
Really
Okay.
not relevant.
No, like
unless they could-
character statements,
no.
nothing like that?
Well, character evidence
That's
is
what I'm
always
wondering.
relevant.
Okay.
And character evidence, the judge will explain to them, you can find somebody not guilty on the basis of character evidence alone. But having his children, they're going to get beat up
yeah,
for bias. So I wouldn't
exactly.
put them on.
And if, let's say, heard something that night, which they didn't, you know, there's nothing.
Is this the end of the road? I mean, is it possible that this could continue?
Well, if he is
after
acquitted, this should probably, and then double jeopardy would attach at that point.
But if he is not acquitted, either if it's a hung jury
Right.
or if there's,
Well, it wouldn't be
let's
a hung
say,
jury at this point.
Well, or a hung
Right.
judge.
Hung judge.
So the
I
judge
think
can't
so.
say that. He could say that I don't know. But that's one of the reasons why they made a mistake here, because they've lost the opportunity for another hung jury. And here's the inertia of a case: once you get another hung jury, you've lost 4 times. At a certain point in time, the prosecution has to give up the ghost.
And it's expensive. You know, this is costing a lot of money for a very
Well,
small town community.
We'll see what the judge says.
I'll be up there.
Yeah,
I'll be
always
covering
like it when you can use the word inertia. That's nice.
Check out Wheel of Justice podcast.
Thank you both for joining us.